Hello, my name is Robert Goodwin, and this is Law on the Line. I would pleased to welcome my guest for this session is Dave Greenfield, and Dave is a colleague of mine and a member of and past president of the Middlesex County Bar Foundation. Dave is a former director of litigation of the Waterfront Commission, and he had in his past life been a research attorney for the Administrative Office of the Courts. He's also a volunteer mediator for the court system, special civil part specifically, and also for the municipal courts of the state of New Jersey. And I welcome you aboard, Dave, and I look forward to having the next 30 minutes to discuss certain areas of the law that you are interested in, and particularly certain aspects of municipal court practice and the practice in the law division in the courts known as the small claims courts and the special civil part of the law division. So, Dave, let's look at what you have to tell us about the municipal court practice from your perspective, primarily as a mediator.
Well, first I'd like to thank you for having me, and I'm pleased to be here. Municipal courts, and I'm going to be very brief on this, are present in every municipality and or township throughout the state of New Jersey. Their jurisdiction handles cases, traffic infractions, drunken driving, parking infractions, ordinance violations such as noise, and a class of offenses called disorderly persons offenses. These are not crimes under the New Jersey Criminal Code, but they are criminal-like offenses. And the trials are held before a judge. There's a municipal prosecutor. The disorderly persons offenses could range from a simple assault, shoplifting, property damage, things like that. A large jurisdiction municipal court handles neighborhood disputes. These are disputes between neighbors. One neighbor, and basically falling into a category called harassment.
Or a simple assault or something similar.
A simple assault. Mm-hmm. Usually somebody will go into a municipal court, swear out a complaint, say my neighbor is saying bad things about me on the internet, he's sending me nasty notes in my mailbox.
These are complaints that are not necessarily initiated by a police officer,
no,
but these are citizens initiating a complaint.
Citizens' complaints. Now, invariably, the citizens' complaints go to a mediator.
And that's what you specialize
Yes.
in municipal court. So tell us about your role as a mediator and what kind of cases you see.
Simple assaults, a lot of harassments, noise. Harassments could take trespass, people arguing over garbage cans, people arguing over parking spots. So
as a mediator, what do you do? And how does, firstly, are the persons directed to go to you? I know you're a volunteer, so explain to our listening audience how this process works. How does it come from the municipal judge, where the parties appear, municipal prosecutor, ultimately to a mediator?
Well, the judge determines, looks at the papers, and might have the parties in front of him or her, and the judge say, this case should go to mediation. And then I'll get a call from the court staff and said, are you available on such and such a date to come in? We're not doing it virtually anymore because, thank God, COVID is hopefully behind us. And I'll meet the parties. And
you're doing this at the courthouse or in a room that's set aside?
Or sometimes I've done it on a computer. I like doing it in person because you could have eye contact. And it's up to me whether I want to talk to each party separately or together. Chances are, if parties are charging each other with harassment, they don't like each other very much. So I'll talk to them separately.
So when you have a mediation, do you discuss that this is sort of an alternate dispute resolution in lieu of what a judge could do?
Yes, I will say that if this goes to court and the judge finds somebody guilty,
Let's say harassment.
harassment. What could happen is there could be fines, there could be court costs, and what is even more important and what I really stress is if you get a disorderly person's conviction, it goes on your record. And that's especially not good if you have an occupational license, such as a teacher or a doctor, because licensing authorities don't look with favor upon convictions, even if they're disorderly persons convictions. So I tell the parties, look, you have this kind of license, don't risk it. Let's find a way to end this so you don't get a conviction.
So when you mediate and you separate the parties, bring them together, how do you ultimately conclude the mediation if there is an understanding reached between the parties?
Well, I'll get the parties to say, I'm a mediator, I can't impose fines, I can't impose costs, I can't charge people money, but what I can do is I could get you to sign an agreement where you promise not to harass each other anymore, you promise not to fight, you promise not to argue, and you both agree, and you agree to dismiss the charges. Very often, when one party charges one with harassment, the other one will charge the other party with harassment.
Reciprocal. Mm-hmm.
So once the stipulation is signed, I tell the court clerk, the case has been settled, there'll be no trial. One thing I'd like to emphasize before I finish about municipal court is and it handles neighborhood disputes, it is not a money court, and I want to stress that. You don't go into municipal court if you want to collect money. I mean, if somebody gives you a bad check or something like that, that is not and that happens to be, could be a disorderly persons offense or a crime if it's a big check, which is heard in a higher court. But if you want to collect your money, you have to look to the civil courts.
As a former prosecutor, I'm now retired, you would have situations where a person would be charged with harassment. And as part of the harassment or malicious mischief, tire slashing. Judge or the parties, because of the complexities of getting the proof, go to mediation. As part of the mediation process, are you in a position to recommend that perhaps a person would recompense the person who has had his tires slashed, or would you recommend that they go to the next level or another level, the civil court?
Well, I will tell them in the interests of justice or in the interests of expediency, look, if you're willing to pay for this guy's tires, this is another way of settling this case. A judge will sometimes order restitution. But in a mediation context, I've had a number of cases, a handful of cases, where parties agreed to pay for damage.
Rather than or in lieu of perhaps going to the civil court.
Correct. But the municipal court should not be used as a money collection agency, such as the civil court.
Okay. And what are the sanctions if a party goes to a mediation and does not return to court to have that mediation agreement, if you will, spread on the record in the municipal court?
Well, usually I have them sign it in front of me. Perhaps stating it another way, what happens if a party enters into a mediation agreement and engages in the same kind of behavior again? So what I'll say is, well, tell the other party, we have a right to come back to municipal court and
on a fresh complaint?
File a fresh complaint.
And, okay, and again, your mediation is not and the results of the mediation don't occur on the same day as the hearing before the judge. Am I correct
No,
about that?
because hopefully the mediation short circuits the hearing before the judge. There's no need for a hearing before the judge if the parties can agree before the mediator.
Very well. Okay, now that, glad we covered that part of municipal court practice. I don't think we've ever discussed that in prior law on the line sessions. We're now in the court where money damages are the primary remedy. And that would be the Superior Court of the state of New Jersey, but we're really going to focus on the small claims court and the special civil part. And what is your experience? Well, firstly, what is the special civil part, and how is that distinguished from small claims, and how is that distinguished from the Superior Court?
Well, it's all a question of money. Small claims has jurisdiction up to disputes of $5,000 and under. Special civil have jurisdiction between $5,000 and $20,000. A case worth that. And I'll talk about the type of cases both courts could see. Anything above $20,000 is heard in our money court is the Superior Court Law Division. There's another division called Chancery, but that's
another,
a completely different animal.
Right. What are the typical cases, that are heard in the special civil part, small claims?
Well,
what are the procedures like?
Small claims is very informal. Special civil is less informal. The rules of evidence are more, I'd say, more adhered to in special civil than they might be in small claims. But you find the same kind of cases in special civil and in small claims. And let me just talk about some of the cases.
Go ahead.
Basically, we could be looking at contract cases. Somebody has a credit card and defaults on a credit card. And either the bank, the credit card company, or what happens these days is the debt is sold to a third party, and it will become the plaintiff, and they'll bring an action against a person who hasn't paid the credit card. If it's under $5,000, they might do it in small claims. Or I have seen cases over $5,000 in special civil too. But if it's over $5,000, your credit card company will be in special civil.
Now, firstly, how do you initiate a claim in either in special civil, small claims, or in the special civil part, where the damages can go from $5,000 to $20,000?
In answer to your question, it's by filing a complaint with the clerk's office. The complaint in small claims is not usually answered. In special civil, there's a formal answer put in by the defendant. And in special civil, you'll very often have an attorney, although in both cases you could have, the parties could be pro se, in which they represent themselves, which is another problem, which we'll get into in a moment.
But the majority of cases in small claims are people are going into court self-represented.
Basically, yes. What kind of cases we're looking at? We're looking at contract claims. We're looking at credit card. We're looking at doctor bills that are not covered by insurance. And when I talk about mediation in special civil and small claims, I'll talk about insurance. Talk about a claim of a contractor, a contractor who hasn't been paid, a contractor will sue somebody in small claims or special civil, and say, oh, we have a contract, and you haven't paid the installments, you haven't paid the rest of the contract. But the person will file a counterclaim and say, yeah, but you did a terrible job.
Now, okay, let's assume that the claim is for $4,000. It's in small claims, and you mentioned a moment ago that you initiate it by filing a complaint. You allege that I don't owe you $4,000. You did a terrible job. But generally, and the court rules, I don't believe, provide for an opportunity in small claims to file an answer. So what happens when you come to court when the defendant, the contractor, shows up and he shows up? How does the case proceed?
I guess as a defense, the contractor brings the action. The person.
No. Yes, the contractor brings the action.
The contractor brings the action. The defendant will say, "Yeah, I didn't pay him because he did a terrible job, and I'll show you why. Well, it's a terrible job, but we'll get to that in a moment." In special civil, the contractor could file, the person who's being sued by the contractor will file something called a counterclaim. And a counterclaim will say, not only didn't I pay him, but he
damaged my property.
He wrecked my property. He did a terrible job, and I'm going to sue him for money also.
So, at what point do you, because I know that you don't litigate necessarily, you mediate. How do you get involved in these cases, both in special civil, small claims, and in the special civil part? How does it work?
Invariably, at least I do a lot of mediation in Monmouth County, and I assume it's the same everywhere else. The parties and or their lawyers appear before the judge at a calendar, and the judge sends each case out for mediation before the judge hears the case.
So there's more than one mediator.
Oh, yes. Let's see. In Monmouth, we have a panel of about 5, 6, 7, 8, 9, 10 mediators
on a given day.
On a given day.
And how many cases on a given day, so that our audience knows what to expect when they walk into a small claims or a special civil
that
court?
Depends. Some days the calendar's light. I know the calendar for June 2nd in Monmouth Special Civil, they got 90 cases on the calendar.
90, okay, so that would be in a week from now or thereabout, 90 cases. So,
but not all cases will go to mediation. One party may not show up. Other parties may ask for an adjournment, and there might be a motion made to dismiss or motion for summary judgment. So not all 90 cases will be sent to mediation. Not all 90 cases will be tried.
So your role as a mediator is to now put these two parties together, the homeowner and the contractor, and what do you do? And where do you do it?
You do it, you assign the room in the courthouse, and usually on money cases, I will hear both together because the tempers usually don't flare as much as they do in a municipal court. I'll hear both sides. I'll let the plaintiff go first. Plaintiff, by the way, when it gets to trial, plaintiff has a burden of proving the case throughout the case by preponderance of the evidence.
That is more believable than not.
More believable than not. You look at the scales of justice. The plaintiff's case has to go, lowers the scale a little bit.
Just a little bit. Okay, so
anyway, that's not what I'm interested in as a mediator. As a mediator, I'll hear both sides. Let me just step back. Whether there's attorney there or not, if you're going into a special civil or small claims, bring bills, bring the contract. Unfortunately, sometimes there's an oral contract, which presents another problem. If you're claiming property damage, bring pictures, photographs, bring estimates, bring a description. If you're a contractor, bring a description of the work done. Well, as a mediator, what I do is I try to get the parties to agree to, let's say a party is suing another one for $10,000. I will ask the plaintiff, what can you live with under $10,000? Because we're trying to settle the case.
Well, let's assume that's the contractor suing the homeowner.
Well, now let's go to a credit card company.
Okay, credit card company.
you ask a credit card company, what can you live with on this type of claim? And the attorney for the credit card company will say, well, my company will let me take off 25%. Okay, and would you be amenable to terms? In other words, so you could look at $7,500 spread out over a period of months or a year or two. And then I would go to the defendant and say, they're giving you a break of $7,500. What can you afford to pay this amount? And we'll go back and forth till maybe we could reach a figure which is less than the original claim and which is comfortable for the defendant. If the case settles,
What do you do?
If it settles for $7,500, we sign a stipulation which says that the defendant agrees to pay the plaintiff $7,500 over X amount of time. And there's language in the stipulation which says, if the defendant defaults on any payment, the plaintiff can enter judgment on an affidavit without going back to court for the full amount of the claim, less payments made on account. So that it's sort of like a sword over the defendant's head. You better make the payments on time.
Otherwise, there's a judgment centered.
Otherwise, the judgment is centered.
So now that you have achieved this stipulation of settlement, is that in writing?
It's in writing. It has to be in writing.
And it's signed by the parties?
Signed by the parties and/or their attorneys.
And how is it then presented to the court on that day?
Well, it depends. Some judges, in my experience, will say, all right, just give it to the clerk. Other judges would say, especially when a person is not represented by an attorney, the judge says, wants the settlement on the record. The judge will say, is this your signature? Have you had any drugs or alcohol? Do you do this freely? Are you happy with your attorney? It'll be more formal. It depends on the judge.
So you've achieved a resolution and the parties have avoided a trial.
Yes.
But let's talk about that, the trial aspect of it, and what you're trying to avoid trying to avoid for the parties as a mediator. What happens if the judge were to make the decision?
Well, there are a couple of very, very good reasons to enter into a stipulation of settlement. Number one, a judge can enter a judgment. Now, a judgment against the defendant could affect the defendant's credit rating. A judgment could be filed as a lien against the defendant's real estate. And if the defendant ever wants to sell the property, he's got to satisfy the lien, which usually comes from proceeds of sale. So it's otherwise the title company is not going to be very happy.
And there's also interest that would accrue.
And there's interest. If the judgment is entered, the defendant could face economic problems. There could be a wage execution where a certain amount of money is taken out of the defendant's wages every week. Defendant may have a bank account, and the bank account could be levied where the money in the defendant's bank is seized by the sheriff.
Now, one of the misconceptions many people have, though, when they go into the small claims court or special civil part, especially when they're not represented by counsel, whether it be through mediation or whether a judge actually renders a verdict after hearing the evidence, and typically there's no jury, and you don't have a right to a jury in small claims. You may request a jury in special civil part, but that's an additional fee.
Yeah, but it's also invariably a rare instance.
Very rare. People think that the money's going to appear that day.
Oh no. That's another sticking point. It's not like an ATM. You get a judgment, you don't put it into a machine and get the money. You've got to chase the defendant. Plaintiff has to chase the defendant in order to satisfy the judgment. And very often, the plaintiff may not be successful. So a judgment which could be renewed every 20 years is out there, and the plaintiff could nail it to his wall and look at it, and it's going to have no force and effect unless the plaintiff can collect on the judgment.
And that would be to facilitate through the court system a wage execution or levy against a bank account, and then a turnover order is needed. So there's a lot of aspects to that. So, and when you not render a decision, but when you mediate a resolution, although there's no automatic payment, do you find that parties are more apt to resolve and pay the obligation as opposed to having a judgment entered? Many
are, and I want to warn give a couple of warnings right now. If a matter is not resolved by mediation, sometimes you get a stubborn plaintiff who says, it's the principle of the thing. I want to go to court. I want to have my day to court. I don't care what I pay my lawyer. I'd rather pay the lawyer than pay the defendant. Mm-hmm. And that's very good. But what happens if you go to court and the judge says, you're not entitled to anything. So by not settling, you might get something. If you fail to prove your case, you get nothing. And on the other hand, if you get a defendant who says, I'm not giving him anything, it's the principle of the thing. And then the defendant goes into court and gets hit with a judgment, and would have been a lot less if the defendant agreed to pay less.
And also, the judgment, again, like you said earlier, would impair his ability perhaps to get credit. It would be a judgment against perhaps his real estate, and all the adverse consequences of a judgment.
One thing I want to mention too.
And Dave, we have to wrap it up, but go ahead. One last thought.
Doctor's claims. Very often, a person will say, my insurance covers that. I'm covered by medical insurance. What happened? What I'll do is I say, get your insurance company on the phone right now and let's see what happens. And what happens sometimes is the insurance company goes, oh, we've got to look into this. There's a problem. So I'll tell the parties, go into court, ask for an adjournment, and let's see what happens.
So you're trying to facilitate and resolve all for the benefit of the litigants.
That's correct.
Dave, we've run out of time. That was, again, another half hour that just zoomed by, and I thank you for edifying our audience with regard to what happens in special civil part, small claims, and in special civil part itself. Thank you again.
And thank you for having me.
My pleasure.